Hey everyone, this is John from Dream Visa Updates, and what I'm about to share with you today is absolutely critical for anyone navigating the immigration system right now. If you or someone you know has an application pending with USCIS, you need to hear this because things are changing fast, and I mean really fast. So grab your coffee, settle in, and let me break down what's happening because this affects millions of people across the country. It's Saturday, December 20th, and I've been digging through the latest immigration news, and folks, some of this is going to shock you. We're talking about application freezes, travel bans expanding, citizenship cases being put on hold, and a whole lot more that you absolutely need to know about. So do me a favor, hit that subscribe button right now, turn on those notifications, and drop a comment letting me know where you're watching from today. Your support keeps this channel going and helps us get this vital information out to everyone who needs it. Now, let me start with the biggest story that broke this week. CBS News is reporting something that has sent shockwaves through the immigration community. The Trump administration is not just maintaining the travel ban anymore, they're expanding the freeze on applications. And this is huge. According to sources inside USCIS, the agency has already started pausing applications for nationals from 20 additional countries that were just added to the travel ban list. Let me put this in perspective for you. The travel ban originally covered 19 countries, some with full bans and others with partial restrictions that applied to immigrant visas, green cards, visitors, and students. But now, and this is the critical part, it's been extended to a total of 39 countries. So which countries are we talking about? We're looking at Niger, Nigeria, Syria, Senegal, Ivory Coast, Zimbabwe, and several others, mainly African countries and some Middle Eastern nations. This is an entry ban, meaning it affects people trying to come to the United States. But here's where it gets even more complicated. After the Thanksgiving Day shooting involving 2 National Guard members, the government announced they would pause processing applications for nationals from the original 19 countries, including applications already pending at USCIS. And now, fast forward to today, CBS News is reporting that the U.S. government has expanded this sweep to include those 20 additional countries that President Trump added to the travel ban this week. A U.S. official with direct knowledge told CBS News, and I'm paraphrasing here, that this move mainly affects immigrants from certain African and Asian countries and represents a major escalation in the crackdown on legal immigration. And let me emphasize something really important here. This isn't just about people trying to enter the country. Many of those affected by this pause are actually legal immigrants already living here in the United States, who are trying to change their status or become U.S. citizens. Think about that for a moment. People who have been following the rules, paying their fees, submitting their applications, living their lives here legally, are now being told their cases are frozen indefinitely. The Trump administration directed USCIS to completely freeze all immigration petitions, and we're talking about requests for American citizenship, permanent residency, everything, for people from these countries who are already in the U.S. And now they're being told the pause extends to these new countries too. A U.S. official who requested anonymity told CBS News on Thursday that USCIS has expanded its suspension of immigration cases to include the new nationalities added to the proclamation on Tuesday. Now, I know what you're thinking. This sounds unfair, right? And you'd be absolutely correct. An entry ban for people trying to come into the United States should not be linked to people who are already here, who are eligible for citizenship or a green card, who are having their cases processed by USCIS. This is going to be challenged, and I mean strongly challenged. But here's something you need to know. On an individual basis, you can fight back through what's called a mandamus lawsuit. This is where you sue the government to force them to move forward on their promise. Because when you paid that filing fee and showed you were eligible, they promised to give real consideration to your case. Joseph Edlow, the director of USCIS, posted on social media recently, and his message was clear. He said that under President Trump and Secretary Noem's leadership, USCIS is ensuring all aliens from high-risk countries are vetted and screened to the maximum degree possible. He emphasized that the safety and security of the American people always comes first, and that USCIS is conducting a comprehensive review of anyone from anywhere who poses a threat to the U.S., including those identified in the president's latest proclamation. So here's my advice to you. Do not lose heart. do not panic, but do get aggressive. For some of you watching this right now, you're going to have to sue the government to get them to fulfill their promise to process your case. But that's not even the only major story I need to tell you about today. Let's talk about denaturalization because this one is really concerning. The New York Times has reported that USCIS has been directed to refer 100 to 200 denaturalization cases per month during this fiscal year. Now, the government's fiscal year started October 1st, 2025. So we're talking about ramping up denaturalization referrals to the Department of Justice's Civil Division, specifically their Office of Immigration Litigation. And folks, this is an astronomical increase. Since 2017, they've only processed 1120 cases total. Let me repeat that. Since 2017, only 1,120 cases have been investigated by this denaturalization unit. And now they want to do 100 to 200 per month? You might be wondering, how in the world will USCIS find these cases? How do they identify people who should be considered for denaturalization because maybe they committed fraud during naturalization or something else happened? Here's the thing, it takes investigation, serious investigation. Right now, there are 26 million naturalized citizens in the United States just living their lives. Some are here, some are outside the country. It's not like these people have appointments coming up at USCIS that would trigger the agency to look at them. This requires looking back in time, digging through records, conducting serious investigative work. They actually started a similar process during the Obama years, looking at cases where the government knew individuals shouldn't have become citizens. They uncovered quite a number of people, though not that large, but they were very slow to actually denaturalize them. When President Trump came into office during his first term, they continued those operations. But here's the reality check. Since 2017, they were only able to handle 1,120 cases. As I've been talking about in other videos, denaturalization requires a very high burden that the government has to meet. It's an incredibly challenging process. On the civil side, they've expanded the criteria for who they'll be considering, including those who commit financial crimes against the United States, and some very broad catch-all categories that could basically catch anyone they decide to target. So this effort to refer 100 to 200 cases each month to the Department of Justice is, let's be honest, a Herculean task. Anything's possible, sure, but we have to consider the fact that it requires massive investigative power and strength on the attorney side. And here's something interesting. An insider who used to work in that denaturalization unit at the Department of Justice revealed in a meeting that they don't have the power on the attorney side yet to pull this off because a lot of people left. Many of the attorneys who had the skill and experience to handle these complex cases are gone. They're not there anymore. So we'll see how things develop, but be aware that USCIS is going to be doing extensive investigative work, which means your cases will most likely be slowed down. Any case before them will be affected because their attention is pulled in so many different directions right now. Now let me hit you with the third major piece of news, and this one's been expected, but it's still significant. The diversity visa program has been suspended. The Trump administration shut it down, and honestly, this isn't really a surprise. They've been dragging their feet for a while now, not even opening things up for the upcoming lottery. They've hated this program from day one, and now they're pointing to the horrific tragedy that happened at Brown University. A green card holder who got his green card through the diversity visa lottery, a man from Portugal who won the lottery back in 2017, came in as a student, won the lottery years later and became a resident, committed murder at Brown University and killed a professor at MIT. So the government shut down this program on the executive side. And here's the thing you need to understand. The executive branch doesn't actually have the legal authority to do this, but they put it out there anyway that they're not going to allow anyone in the country through the diversity visa lottery program. Secretary Noem posted on social media about this, saying that this individual should never have been allowed in our country. She stated that at President Trump's direction, she's immediately directing USCIS to pause the program to ensure no more Americans are harmed by what she called this disastrous program. Litigation has already started to challenge this decision because the diversity visa lottery program can only be suspended by Congress. It's their idea, their statutory scheme. They set this up, so Congress, which frankly isn't functioning right now, has to be the one to make this change. We don't have a functioning legislature, Congress has to act, but they won't. I'll keep you posted on the litigation surrounding this issue. Here's another development that caught my attention. The first military immigration judge has been fired. He's only been on the job since October. He was a JAG attorney serving on the bench in Virginia, and apparently he's too lenient. Out of 11 cases or decisions that he made, 6 were favorable to immigrants. He granted asylum and other relief. This early track record wasn't what the administration hoped for when they placed him in that position, so he was terminated. But let me share something really important that I've been discussing with colleagues. Although these military judges, these temporary judges, are deciding immigration cases around the country, some of them aren't actually doing a bad job. Some are being very fair because they don't want to lose their licenses. They don't want to get in trouble. They're not about to take on this assignment and just do the wrong thing. Yes, they're issuing removal orders at a slightly higher pace than traditional judges, but they're not way out there yet from what I'm hearing through professional channels. These military immigration judges, at least some of them, are being fair and doing their homework to learn the facts and the law in front of them. But this first one got fired, apparently for being too lenient. There's also news about a Wisconsin judge, Hannah Dugan. She was convicted this week, found guilty of obstructing justice. Remember several months ago there was video of an incident where, according to allegations, once she knew ICE was in the hallway looking for an immigrant, she allegedly allowed him to leave through a back door. There was a chase, he was eventually caught, but she was found guilty. She's going to continue her fight, but this is significant because she's the first judge during this Trump administration to face such a serious charge and be found guilty of obstructing justice. Now let me address something that a lot of you have been asking about: marijuana. You might have heard the news that this week President Trump signed an executive order reclassifying marijuana from a Schedule 1 controlled substance to Schedule 3. The motivation behind this has a lot to do with the medical marijuana lobby. There's serious money involved in marijuana research and development. But here's what you absolutely must understand. This does not mean any change has occurred on the criminal side. It does not mean marijuana has been decriminalized. And it certainly doesn't mean immigration sees marijuana any differently than before this executive order. Marijuana has always been a tool that policymakers use in enforcement. And I don't think they're ready to give up that power yet. The federal government still sees marijuana as a serious problem, and it is still a crime to possess it, sell it, distribute it. So if you're a habitual smoker and USCIS or the U.S. Embassy finds out about your habit, they will not approve your case. If you have a marijuana possession conviction on your record, they will still view that as a problem unless you qualify for the waiver for 30 grams or less, single possession. Those laws are still in place. Don't think for a second that because marijuana is now Schedule 3, like Tylenol with codeine, that it's not a big deal anymore. It absolutely is still a big deal on the criminal side and on the immigration side. So let me wrap this up because I know this is a lot to process. We've covered the expanded pause on applications from 39 countries, the push for massive increases in denaturalization cases, the suspension of the diversity visa program, the firing of the first military immigration judge, and the marijuana reclassification that doesn't actually help immigrants. If anything major happens over the next week and a half, I'll be back with updates, probably through short videos on social media, so make sure you're following Dream Visa updates on all platforms. I'm happy to address some common questions before we finish up. If you're from one of the banned countries and your naturalization is coming up in the next 6 months, and you have a clean history, watch and listen for possible injunctions that could address the pause USCIS is placing on applications. If you already have an application in process and you know you have a good case, seriously consider filing a mandamus lawsuit to force the government to fulfill its promise. For those asking if their children can file for them as soon as the child becomes a citizen, yes, once your child gets that naturalization certificate, they can absolutely submit a petition for their parent. For approved employment-based cases like national interest waivers, remember that immigrant visas are part of the ban, and you have the burden of showing your endeavor is in the national interest. Green card holders need to understand that you're not banned from entry. The travel ban specifically excludes green card holders. However, if you're in the United States and you're a national from one of those banned countries with an application at USCIS, They may have paused it based on your country of nationality or birth, even if you entered on a non-banned passport. The key thing to remember is this: don't let all of this rob you of your peace. It's the holiday season. You've got to lean into the joy and rest that this time of year offers. I'll be back with a special holiday show on Monday at 1 p.m. Eastern Time, so make sure you join me for that. We'll have a peaceful time together as we look to wrap up the year. Stay informed, stay strong, and remember that knowledge is power in the immigration process. Subscribe to Dream Visa Updates, hit that notification bell, and share this video with anyone who needs to hear this information. I'm John, and I'll see you in the next video. Hey, take care and have a wonderful rest.